Sir.
Okay, thank you. Yes, I'd like to take this minute to call to order the City of New Bern's Board of Adjustment regular meeting, January 25th, 2024. And would like a roll call, please.
I'm going to start with Board Member James Ferguson.
Here.
Board Member Kathleen Marty.
Here.
Mr. Chairman.
Here.
All right. And Mr. George Jones, who's absent. Ms. Sandra Gray.
Here.
Mr. Eric Thompson.
Here.
Ms. Barbara Sampson.
Here.
Mr. Mike Duffy.
Here.
And Mr. Brendan Lofton. He is absent as well.
Okay, thank you.
Yes, sir.
And we have a quorum.
Yes, sir. We do have quorum.
And we'd like to do the Pledge of Allegiance.
I pledge
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yes, I have a couple of comments to start out, and really would like to reiterate to everybody that this is a volunteer board. We are not elected officials. We are here to try to help the public make good decisions and facilitate the process. And so this board is, and I'm going to try to read a little bit here in reference to how the process works. And we're a quasi-judicial hearing board, which proceeds very similar to a court. We ask that you all respect everyone in attendance and do not engage in disorderly outbursts or disruption. And last go round at meetings, and take a break here for a second and say that we really did not require a minute limit. And I think there's going to be some discussion later today to potentially discuss maybe 3-minute limit to conversation. I think we got a little long-winded, maybe a time or two, and we probably could have said a lot better statements in a shorter period of time. So we might try that in the future. If anybody intends to speak, and I was going to say there's nobody here tonight, so I'll try to rephrase that. I apologize. If a person intends to speak, please be mindful. If a person does exceed a time limit, if we so choose to put in the 3 minutes, I, as the board chair, will do my best to say that we're at the limit and move forward on to the next person. And really, that's done to try to facilitate, give everybody an opportunity to speak. And I really don't want to hit the gavel. That's not something that's pleasant for, I think, myself and or the board members and or the public. So it's a thing that we need to try to figure out how to work out, and we'll move forward as the board progresses throughout the season. And I say the season for this year. It's the board's policy after the presentation is heard from staff to allow the applicant to speak first and last. Citizens have signed up, or we hope they have signed up to speak. Will have an opportunity to provide their testimony. Two things I would like to add to this. We would like people to sign up ahead of the meeting, name and address, and we'll actually have a list here at the front, and we can try to check off. That's our intent. And so if a person does desire to speak who's not on the list, we will ask you all to sign up, and so we can move on that way. While the board can only consider factual evidence or expert opinion in its decision, reasonable conditions may be applied based on the public's testimony. So again, it's not necessarily deemed reasonable for a person just to say we know traffic's going to be increased. I mean, the people have spent, when I say people, the applicant in many cases have spent a tremendous amount of resources to come up with a traffic study that has been done by professionals. And we have to, as board members, look at that as evidence. Just an opinion is not technically evidence, so please respect that in the future as we move forward. And I think that's done with the comments. Is there anything that I might have missed that a board member may wish to add to those comments? Okay. So our first agenda item is a decision that we discussed at the last meeting, the Thrivemore community, and we need to take a vote to approve or disapprove that decision that we made at the meeting. So we're here to open for a motion.
I move that we approve the Thrivemore community parcel request.
Second.
Okay, so we have
I
a,
think the motion is to approve the Thrivemore community written decision. Is that your motion, Ms. Martin?
Yes, ma'am. Written decision.
Second.
okay, so we have a motion and we have a second. And I believe it's policy that we can only have board members that were here present during the decision vote. And so first thing I'd like to know, do we have a quorum as far as folks that were here for the decision?
Yes, sir.
Okay, and I guess we should do a roll call on the decision since it might be confusing that some folks were here and some folks were not.
If you'd like to do roll call, I absolutely can.
Okay, so I think that might be good tonight since there's nobody in the audience and it may be a little confusing. That's not something we have to do. I'll bring that up since we had some comments earlier. We'll move forward. Okay.
All right. For the first board member, Ms. Kathleen Marty.
Aye.
Okay. And then second here, Mr. Chairman, Tim Tabak.
Aye.
All right. And for the third board member, Mr. Eric Thompson.
I was not present.
You weren't present? I apologize. I thought you had been. Ms. Barbara Sampson.
Yes.
All right. Just a moment here. And then Mr. Mike Duffy.
Yes.
Okay. Mr. James First.
Yes.
All right. And that would conclude.
So the motion carries. We have approved the decision from the last meeting. Moving on to the next item, comments. And so I'd like to really open up, and if some of the board members would like to expand a little bit more on our earlier discussion in reference to time, limitations for speakers, or any other part of the process that may help us facilitate a better discussion.
Well, what the Board of Aldermen does when they review zoning changes, which is a different, rezoning, is they ask that people limit their comments to new areas of interest, and that if someone's there, they try to pick someone to speak for the group wherever possible. That seems to work reasonably well. So, although on the Stars and Stripes one, there were so many people that literally took 2 hours, and there was another matter that, and they both got turned down. But that's another story. But, so that's the way they do it. The number of people, it would have taken 3 hours no matter what. They were just, the place was filled. So,
Yes, it was.
so one of those things.
Yeah, and I would
There's a
tell.
lot of back and forth with people coming up and coming down and so on and so forth. Another thing though that I'd like to add, I had brought this up before you guys were in office, before the change, and I had got put in a request to that the table of permissible uses should be included in the package, and forced to use even in fact that it would be done in the future, but it doesn't seem to have happened for us. So I think that would be a good idea for us to have it as part, because when we're looking, my thing last time, when we're looking at what could happen if we don't approve this. Follow what I'm saying? So, and so we should know, what we might, because, so if they put in for something else, then, that could be worse, so it gets us,
We could certainly print those off and
Yeah.
keep them with, let's say, like their name
Right.
tags.
Yeah, yeah,
You gotta come up to
So
the
we can
microphone.
get your
yeah.
Beautiful.
Robert Goff, I'm the Assistant Director of Development Services. Yeah, we can certainly include a table of permitted uses in each one of those packets that you received. We'd likely include them with the name placards that we keep for the board meeting as well as the gavel. And we'll just keep all of that stuff together, and you can use that as reference material.
Yeah, I'll make sure it gets added to the package for you. So that's a good point, and I can understand.
But it could even be permanent. What they used to do in a committee that turned out to be a total waste of time, so really wasted tremendous city resources, was Appearance Commission, which I was on, because again, they couldn't get anybody else. And, but we did have booklets, with a copy of the ordinance and so on and so forth, so that might be, so you don't have to print it for us every single time, it doesn't change.
No, yeah, we would just keep it with your name
Whatever's
placards.
easier. It'd be good to have it there to know exactly, if in case we turn something down and the person decides to, propose something different. But we're all very limited in turning things down. So it's a consideration.
Yeah, I think that, well, the point taken on the zoning requirements.
That's why I was asking last time, what else could be done there? I was thinking in case we turned it down.
Yes, sir.
I think in some cases, and I mean, staff can correct some, how far can we go? Is that starting to get outside some of the limits as far as the data? Or, Jamie, I mean, I see your eyes, that's why I wanted to ask the question.
No, I think it's entirely appropriate to include the table of permissible uses in the packet. It's also available online with the Code of Ordinances, but if you prefer to have a written copy, I think Mr. Assistant Director has agreed to accommodate that request. But it is germane to your considerations, because one of the questions you have to answer is whether the use that's being applied for is allowed by the ordinance. So it's certainly relevant to the considerations that you're considering.
Yeah, thank you. Yeah, great input. Yeah.
When you were talking about the time limit, I think it's good to have some type of rule in place, even though we haven't had a whole lot of people to really come up and speak, but we can put that rule so in the future we don't have to worry about trying to make it in.
Yes, and I also think that having a group speaker, it was stated earlier, that's phenomenal. It's probably in some cases speaking to the public difficult to have a group speaker. Many times people come to the meetings and don't even know their neighbors anymore, or respect them enough to speak, and I know that may be a challenge. However, I would encourage people to get together and at least if it's a common goal, because it is difficult to hear the same words repeated time and time again from a logistics standpoint and keeping time up. Thanks.
I believe one of the changes we talked about making is that they're signing up to speak,
Correct.
putting in their address. Can there also be a spot on the sign up, yes or no, or check whether or not they received a notice of the hearing? Because it's my understanding that notices go out to all individuals who would potentially have standing. And so,
Yes,
I'm sorry?
It's a buffer that's created
Yeah.
from the parcel or the property.
And so, and please, I guess I have a question. When we have these hearings, do we have to have public comment on the special use permits that are presented?
As I understand it, it's been included in all of the different hearings that I've experienced. And I don't know if it's a particular statute, however, it pertains to them having standing. It is written through the statute and it talks about standing
Right.
per individual.
Right.
So the receiving of that letter, in that sense, it's
Yeah,
it can be
and
questioned.
that's, I guess, my thought with thinking about the last hearing that we had. If, we had on the agenda the permit applicant and then those in opposition speak, and then a separate public comment period, those in opposition that can speak during that permit time, have to have standing. I'm not saying we limit public comment period if there's going to be a public comment period, or just so we're aware. And even if we do let them all speak, make sure we have a record of whether or not they received a notice, because I think that would be germane to our considerations of whether to take their testimony into consideration.
And just to make sure that we're all speaking the same language, Mr. Ferguson, you're referring to the evidentiary hearing where notified proponents or opponents can offer evidence, and then a separate public comment period where anybody in the world can come and address you about anything. So when we're thinking about those two very different concepts, you may want to analyze them very differently.
Yeah, I think, and so I guess that's my question, is during the evidentiary hearing, is it required that we have a public comment period during that hearing?
That is not required.
Right.
The statute and the case law dictates that if someone is coming to offer evidence about a particular proposal, the threshold issue for you all is to determine if that person has standing. So that may be helpful by having the person's address and whether they were a notified person. Now, that may not bar someone. Someone may be able to offer evidence to demonstrate that they would be, particularly harmed, different than other people in the world, and can demonstrate standing. But that's one of the threshold issues that you all have to consider before you can weigh whether the evidence that they're trying to offer is competent or material.
Okay.
It may get a little muddled in the sense that evidence is presented during public comment. It would be the board members' position to determine whether or not they have standing. So they could present evidence during public comment, and any person from the community who has interest in it could also present their comments and not have standing. That's not something staff necessarily checks, because anybody driving by can see a public notice posted on the property and not be affected and not have standing. That's something the members of the board would have to sift through if that's something they wanted to undertake.
Okay.
If we're going that way, I think we'd have to restructure it, because as it stands now, we have people come in, and if they plan to offer to speak, we ask them to be sworn in. So we might have to readjust that, because you can't very well swear them in and then tell them we're not going to listen to you.
And it sounds like, just from a logistical, and correct me if I'm wrong, but it sounds like from a logistical standpoint, we continue the process as is, but make sure we have their address, make sure we have whether or not they received a notice, and then if the board has not been able to ascertain whether the individual speaking during that hearing has standing, that we can ask questions of them to establish that. And that way we're not excluding anyone into pushing them into a public comment section when they should be presenting evidence.
Absolutely.
Okay.
That is something that you can do, correct? Yes. And an applicant, if they've hired representation, if they have an attorney I've seen in the past, that attorney may question whether or not the person speaking against the item has standing. And that's for the applicant's representation.
Just a couple of comments or suggestions. Also, with the sign-up sheet and the addresses and names, is it possible to develop a map? So a lot of us don't know the communities very well, and so if somebody gives a name and address, they may not know how that's associated with a particular piece of property in the application. So with each one, is it possible that the folks that get notification be on a map to where we could see that, or is that something is that permissible?
So there's a couple different things in terms of that specifically, but yes, I can absolutely have probably one of the folks that work with the GIS, they can produce a map that'll show that buffer area, so to speak. It's like basically what it does is it draws a red circle surrounding the parcel and then gives you that 100-foot distance to show you and encompass the adjacent properties that would be impacted or receive a letter in that sense. I can also include probably a mailing list that gets generated, because that's how that process works with the Creighton County GIS. Once you do it, you can generate a mailing list that gets exported, and then it gives you the different folks that got mail, or essentially are in that 100-foot. So.
And I think that would help us as board members, determine the standing process. And then the second comment would be, from an agenda standpoint, is it possible to split the meeting, public comment versus people who were notified, have them, or is that something that we don't want to address or get into?
I think we may be, overreacting to this a little bit, because in this particular case, don't forget, the petitioner, the property owner, contributed to the problem, by going out to speak to the homeowners association at Carolina Colors and triggered this attendance himself. They wouldn't have known about it otherwise.
And Mr. Chair, in the spirit of being helpful, I don't think public
So I'm not sure that's going to necessarily happen again. So,
Sure.
so it's turned out to be, I think, a mistake on his part. But a lot of the acrimony and stuff came from people who we told at the meeting, at this meeting, that he decided to do on his own. Because he was an officer of that organization. So
I don't think public participation is a problem necessarily. I think from an evidentiary standpoint and a logistical standpoint for you all, you want to make sure that the evidence you're receiving is actually admissible. And it may be that in your recitation or your comments to the public and structuring the hearing, that you all you give the applicant an opportunity to present the application, then you offer the floor to notified opponents. So people who received a letter in the mail that gives us a baseline understanding that they may have standing, then notified proponents, people who are in support of the project, and then anybody else who might be able to demonstrate that they have standing. So whether they received a letter or not, if they're able to come up, if they're just a member of the public, as Mr. Duffy alluded to, that may be able to offer some evidence to you all about some special circumstance that gives them standing, then you can give them an opportunity to speak. If there are other people who are not able to demonstrate that they have standing, you do not have to entertain their comments. But you may choose to do so because you may find that there's some value in allowing the public to speak. Now, when you get to your deliberations, how you weigh that evidence is going to be different, if that's helpful.
I think very much so.
And yeah, and I agree with the chair that I think that structuring the agenda that way so that the audience who's in attendance knows when their particular time to speak. Because I would very much like to hear those notified in opposition, those notified in support, and then open it up to the public in that order. I think that's a good way
We
to
could
structure
certainly work on the dialogue that the chairman or members of the board would have when conducting the hearing. We can certainly work on something to accommodate that. And I can touch kind of on the whole concept of a map of all those who sign up. That logistically and as far as the timeline's concerned, that probably would not be a thing that could happen because the list is created at the meeting and we don't have GIS staff who can produce a map immediately for you.
Sure.
But the mailing list is something that is generated as soon as we receive the completed application and we start processing it, and we can certainly include that. That is competent evidence.
Yeah, I think that would be most helpful. And I guess on the website, the definitions of standing, definition of evidence, is that something that may be included to where a particular applicant or a person that might want to speak would then see what we struggle with? Because I think in some cases there may be a difference of thought process about we as the board think is standing and is evidence and or what a particular individual as public would be, and to try to facilitate.
Well, the last set that was sent out, that was in the letter, that was included in the letter, that we were only allowed to consider certain things and so on and so forth.
And Mr. Chair,
It wasn't neglected altogether, it was there.
Mr. Chair, as far as the standing and the definition breakdown for that, there's not really a specific breakdown or definition that I'm aware of. So that kind of falls to what Ms. Janey was stating here, as far as for your discretion and the board's discretion in terms of making that decision as to whether or not that person has standing. What may be beneficial in that situation is to explain the rationale behind what your belief is to the individual. So that way maybe it's better received, if that makes sense. That's probably, I think that's the only suggestion that I can really give. So,
Yeah,
But
sure.
for our purposes, on the proximity, the 100-foot proximity, isn't that only germane to us in terms of property values?
No, sir.
No, it's across the board. Okay.
So, question on the time constraints, most certainly with the speakers, with regard to a group speaker, would it be possible to add a provision to allow them maybe 5 minutes if they're going to speak on behalf of a group versus only 3 minutes if an individual comes to speak?
Yeah, and I think that's something of consideration for all of us, and I totally agree. I think that'd be a great idea.
Because that would be condensing a group of people with one speaker. Am I understanding that correctly?
correct.
Okay.
Yeah.
Technically, they don't have to limit themselves to one group speaker. They can have multiple speakers.
Yeah.
If they feel that they can't limit to one person with 3 minutes, they can designate a couple people.
Okay.
And I have some heartburn with the. I mean, I think we can encourage, if you're all opposed to this, if you come up with a group speaker, we can encourage it. But I have heartburn with any type of requirement there, because I think if there are 20 people sitting there withstanding that want to talk about it, I think we got to give them. I mean, we have to give them their opportunity, or else we're denying them that opportunity to speak.
That's correct. You don't have to designate somebody a group speaker.
So-
It's just something that's encouraged.
Yeah, I think we can strongly encourage it, but I don't think we can make a policy to do that. So
And that's not my recommendation. Just
yeah, I just want to make sure that.
And yeah, I guess from a leniency standpoint of letting the clock here go a little bit over would be well within the realm of what we can do. I don't think anybody's going to be looking at a clock other than, unfortunately, I guess whoever is myself sitting at the board and whoever's to my right will be able to see it. But and we can kind of work it out from there. And I think a comment that I think Jamie made in the decision, I know some of the discussion by each of the board members as they make responses to comments and or ask questions, to be able to expand on the process about why or what or their thought process would definitely go a long way to, I guess, I'm struggling with the words I want to use here, but really help both the public and other board members understand the thought process to determine standing and or evidentiary versus not. But am I going down the right road, Jamie?
I think so. I think having the introductory comments in the beginning, talking about the process and laying out the format for the hearing is going to be very helpful, because it sets everybody's expectations at the outset. And then as you get into the hearing and you are asking questions, let's say of someone who did not receive a letter for whatever reason, but may be able to demonstrate standing, in that inquiry that you all are making as fact finders, once you are satisfied that you have sufficient facts in order to make a determination about that person's standing, you can make those pronouncements during the hearing, which will articulate what your rationale and what your thought process is, if you find yourself in such a scenario.
Okay.
Can I just have like a question so I can make sure it's clear? Okay, if a person have a professional opinion about any item we're talking about, maybe like drainage or endangered species, and they don't live in that affected area, but they might be a concerned citizen or maybe a community leader somewhere else, will you still weigh on what they're talking about?
That's a very good question. So expert testimony is required on certain elements that you all consider. And if the notified, let's just say opponents, for example, have retained an expert to offer expert testimony, then I think you certainly could consider that testimony, so long as you're satisfied that that person is an expert in a topic that is germane to the considerations that you all are receiving. If somebody has a PhD in something that is unrelated and just wants to talk because they're a super smart person, then you may analyze that factual scenario completely differently. If that answers your question.
Okay, yes, I was just making sure that you didn't have to live in an affected area in order to have a professional opinion.
No, that's correct.
Yeah.
And the same can be said if you're within 100 feet. Just because you live within 100 feet does not mean you're providing expert testimony or evidence. That is still something that you would have to determine. The 100 feet just determines they have standing.
Fair enough. And so I guess back on the mapping question also, since we got back to the 100 feet, is it possible to have other addresses, just 10 or 15 that are outside the 100 foot, again, just so a person, if somebody spouts off an address, they know that they live within a specific area versus not so much? And if not so, and I guess where I'm going with it is when it comes to the standing process, if a person lives on the same road with an address that's 5 miles away, just
And you can
where do
ask
we go
questions. You can ask questions of the speaker. I understand you live at 123 Maple Street. Does your property line touch the subject property area? That might be one question that you ask. If they say no, okay, then they're not adjoining or abutting. Is your property within 100 feet of the subject property? If they say no, then that also gives you some more evidence to weigh as to whether they have standing.
If they're 200 or 300 feet away, that's something that you can reasonably say that is close, and they could reasonably be affected by something. Let's say traffic. Let's say they're a professional in traffic, and they live 200 feet away. You could say it's reasonable with your qualifications, as well as living reasonably close, that you have standing and you are also able to provide expert testimony. Just because it's not exactly 100 feet does not mean you have to limit yourself to only those within 100 feet.
But I think the commonality between what Robert and I are saying is you all as the fact finders can ask questions. So if the map is insufficient to satisfy you about whether the person is close enough to have standing, you can ask that individual additional questions to understand where their property is related to the subject property.
And each and every one of us has that opportunity, in the discussion process. If one of us may not even make a comment because we may have knowledge of where that address is or whether that person may or may not be a professional, well, somebody else that doesn't, feel free during the comment process to ask, because we're all in it together and we all have different expertise that we may not be aware of, and it's all a process to where we can all come up with a good decision.
I will state this, it's generally pretty easy to determine whether a statement can be considered evidence or factual testimony, and in most cases that I've seen in all the different jurisdictions I've worked, there's not really an issue with determining whether or not somebody has standing. So this might be getting a little too far into the weeds. Generally speaking, all folks are allowed to speak, even with or without a time limit, and it's still the board's job to determine whether or not, A, they have standing, and B, this is factual or evidence.
Yeah, well stated. Thank you. Are there any additional comments by board members before we move to the next agenda item for Kendrick to speak a little bit about his thoughts?
Just a technical point. If there is a street in between the cross-section of that street does not count towards the 100 feet. So theoretically, you could be further out. So I guess it was like Broad Street or something like that. So people on the other side would be theoretically within 100 feet. By the statute. So,
If let's say the 100-foot would determine one side of the street versus another side of the street, it's reasonable to assume that the other side of the street may have standing.
Yeah.
They just may not have gotten the letter.
Fair enough. And we all make mistakes too, so something may have happened or somebody moved, address changed, so we all have hiccups that we need to try to work through, so sure. Any more? All right.
Well, I appreciate all the comments. I'm going to do my best to try to address some of that. And we kind of bled into a little bit of similar with some of the staff comments that I was going to make, just in relevance to the procedure and updates to the processes and whatnot. I want to try to make it as smooth as possible to proceed, and just to kind of touch on some other, I guess the same similar, but the implementation for the time limit, these are things that are discretionable and going to be essentially left up to you. It's just to try to make more fluency throughout the actual meeting in itself and try to contain any disruption or disorder that we kind of experienced in the first meeting. Leading into that, that's kind of like a segue. The reason I am kind of reiterating that is the point that our next upcoming meeting, which is going to be for February 22nd, this is going to have a very similar item in essence, and this is the start of the strike project. They're doing the same similar use as multifamily residence use, specific to just that. And basically, it's going to draw some contention as well, most likely. So if we can kind of avoid the similar situation that we just experienced from Thrivemore, that would be the goal and the objective, is to try to increase the fluency and make sure that we can contain any disruption. There'll be some other or additional things that are put in place. I'm going to also be contacting, our local police department to kind of stand by in essence, necessarily for that meeting, just in case. So that should kind of help solve some of that. But the project coming up, as I said again, is multifamily residence, same similar, rather large, mixed. I believe it's going to be single-family dwellings and townhomes, if I'm not mistaken. So you'll see that February 22nd. And it's going to be the only item, at least for that hearing. So, but
Something to look forward to.
yes, absolutely, yes. Outside of that, we talked about most of what I was going to discuss as far as, like I said, the process of procedural updates. I appreciate all the input again. I'm going to do my best to try to see that that gets implemented as smoothly and quickly as possible. So, but if you would like to move to adjournment, Chairman, you're welcome to do so.
Fair enough.
Question?
Yes, yes, ma'am.
So the dates that you gave us for the meetings are confirmed and
Yes,
in
ma'am.
place?
Absolutely, yes.
Because
ma'am.
I thought there was some back and forth with some of the emails, but
I got you. No, those dates that you received are confirmed.
Confirmed.
The only way that those will typically change is if for some reason we do not have a quorum, then I will reach, of course, back out to everybody and say, hey, we don't have a quorum, so the meeting has been canceled, and you'll receive a cancellation notice, and basically it gets broadcasted to everyone to make sure that nobody's left out. But yes, those dates are confirmed.
good. Thank you.
Yes, ma'am.
And just so the record is clear, I think staff has clear direction, is there a consensus from everybody to impose a time limit for speakers for upcoming hearings?
Yes.
Seeing some heads shake
Yes.
yes.
Do we need to take a vote on that?
Yeah.
That- As long as everybody's in agreement and everybody's clear, I heard a couple of numbers tossed out. Is it the direction you're giving staff to develop a policy to limit individual speakers to a maximum of 3 minutes?
Yes.
Yes.
They say unless it was a group, if it was a person talking for a group, they said 5 minutes, right?
Just, the first
I'm just
question is about
making sure. Oh, I'm just
individuals.
making sure.
Individuals, 3 minutes.
Yeah,
Is that
okay.
the pleasure of the board?
Yes.
Yes.
Sure.
I'm hearing no nos. Okay, and Ms. Sampson was getting to groups. If a group wants to elect one or more spokespersons, that time limit should be
5 minutes.
5 minutes.
5 minutes per spokesperson.
Yes.
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 If the group has more than one, I think you have to give each of those persons in that group the 5 minutes.
Just to interject, I guess we had a similar occurrence actually with the previous item. I don't know if you all remember, but they had the engineer, they had their traffic
Yes.
person. They also had, I believe, a surveyor to some degree, or an appraiser at least, and then you also had the actual applicant himself, who was, he was essentially involved to that degree as well. Most of those gentlemen and those young ladies were experts in that effect, or a group spokesperson. So each spokesperson could ideally retain 5 minutes, and just to consider.
Would it be fair to say that a group could be defined with maximum 3 spokespeople, and beyond that, we convert back to just individual timelines at that point?
That's kind of
If we're at 4, then we would be 3 minutes per person, but 5 minutes per person up to 3 people for a group spokesperson.
Yeah.
I think that would work better.
Yeah.
Does everybody understand?
Yeah.
Is everybody in agreement?
Couldn't,
Yes.
I should make, okay. So you're saying if there's a spokesperson
Appointed for a group.
appointed for a group,
Mhm.
and no more than, you said, but 3 spokespersons?
Correct.
I think that would make the
Then that would be
most
maximum 5
Yeah.
minutes per person.
So in that, I just want to, if you were to apply that to Thrivemore's situation, they could only have the applicant and 2 other experts? Is that the effect of the rule?
And then if they were trying to add any more, they would just revert back to the individual.
To individual 3
minutes.
each?
Yeah.
Because what you might get.
And so if you have more than 2 experts, applicant and 2 experts, you end up getting 3 per minute.
Right, because what you might get is you'll have 7 experts, and they all want to be defined as the spokesperson, and you have 7 times
35
5, that's
minutes.
35 minutes
Mhm.
alone that you're allotting to just them. You know what I mean? And it becomes exploitable.
No,
That's the only
that's
thing.
a really good point. I just want to make sure I'm clear on
And,
that
I mean,
point.
I-
I think it's also important to point out that if the board has questions for a particular expert on the applicant's side, that's not necessarily public comment. If the board wants to ask the applicant's engineer to come up and make a comment on something you may need clarification on, that's not something that we would place a time limit on.
Yeah. My only concern, and I guess, to Kendrick's point, it converts back if you have more than 3, so this concern is addressed. But if you have to have more than 2 experts to meet all the elements of a special use permit, you want to make sure they have all the time, they have the opportunity to present all their evidence, but if it reverts back to individual, then I think that's appropriate. So I'm good with that.
So everybody's good?
Yes.
And that's the direction you're giving staff to bring that policy back for implementation at subsequent meetings?
Yes.
Yes.
Okay.
I believe just to add into that, the other point that should probably be a discussion between you all, but how many times folks are able to move back and forth to the mic, which I understand, there's always a rebuttal in most cases, but there has to be a limitation. The applicant is going to be first and last. And then Mr. Thrivemore, you saw what we were experiencing was constant up and back, up and down of the same individuals. That's an increased point of time, basically, that they're occupying at the podium. Some individuals were coming back and forth about 4 or 5 times.
Yeah, no, I think it stays unless, if it goes to a situation where they're individual speakers as experts, then they're capped at 3 minutes. And then if you have a situation, once they're done, they sit down, opposition can go up, they sit down, applicant rebuts. I don't think there needs to be any back and forth.
That's where
And that would be, I think, should be articulated in policy. My only thought for anyone who has to come up and back and forth should be if they're represented by an attorney who's lodging an objection, so we get it on the record. That would be my only.
Or I'd probably say if you as the board, asked,
Or if we wanted them to come back and talk,
need to
but
clarify something, that's absolutely, I would understand that.
yeah, but I don't think what we had last time. You don't have folks in opposition continue to come back up and rebuttal, and you get this back and forth now.
Yes.
So, however you want to articulate in the policy, I think that's a really good idea.
I had basically written it out as they have one opportunity to come up and voice their explanation pertaining to the item that should, of course, be in line with that item, as far as if you determine they have standing to actually discuss that item. If they don't, then they can be asked to have a seat and the next person be brought up to begin their explanation.
Yeah, and I would encourage all the board members to make some notes, pretty specific, to try to help facilitate this also, because if we do limit time, the time to get to the bottom, we'll say will be through conversation by the board members back to specific individuals if we need additional information. And so having good notes put together, we can, ask good questions of those people. It'll help make the process move on a lot faster.
And that's it for me. I appreciate the explanation, Ms. Jamie.
Do we have a motion to adjourn?
I make a motion, we adjourn.
Second.
All in favor?
Aye.
We're adjourned. Thank you.